Question number 5 asks state the circumstances in which a surety is discharged, and regarding that discharge of a surety we'll discuss the very opinion expressed by Lord Justice Chancellor in the leading case Bonshire versus Cox in 1844. So, the principle underlining the rule that a surety is discharged from its obligations as such is that the contract of suretyship is a peculiar type of contract. By such a contract, a person takes upon himself the liability of carrying out another person's engagements. As such, the law watches very carefully that the surety is not called upon to perform any contract other than that which he himself guaranteed, as it was expressed by Lord Justice Chancellor in 1844 in the leading case Bonshire versus Cox. So now we'll discuss the very surety is discharged from its liability to the creditor under the following circumstances. So, as provided under section 133 by alteration in terms of contract, and second one discharge by principal debtor as provided under section 134, then discharge by operation of law, and the fourth one as provided under section 135 is compromise, and the fifth one as provided under section 141 as release of security, and section 1 to 39 provide inconsistent act of the creditor, then the death of the surety as provided under section 131, then automatic discharge as provided under section 144, and lastly by invalidity of guarantee as provided under section 142 and 143. So, as relating to alteration in terms of contract, so a surety is discharged from his liability in case of variance of terms of contract. Any variance made without the surety's consent in terms of the contract between the principal, debtor, and creditor discharges the surety as to transactions subsequent to the variance. So, in the leading case, Ward versus National Bank of New Zealand, the Privy Council held that long series of cases had decided that a surety is discharged by the creditor dealing with a debtor or with a co-surety in a manner at variance with the contract, the performance of which the surety has guaranteed, and in the second important case, the State Bank of Patiala versus Messrs. Sri Durga Oil and Flour Mills and others, in 1984, the Himachal Pradesh High Court held that when there is no evidence that the terms of contract were ever varied by plaintiff and principal debtor without consent of surety, the liability of surety could not be discharged. And the second one, that is relating to discharge by principal debtor as provided under section 134. If the principal debtor has exempted surety from his liability, then he shall stand discharged from the liability. And the third one, that is discharged by operation of law. So a surety may be discharged by operation of law. Thus, pursuance of legal consequences, liability of a surety may comes to an end. For instance, K, a Harijan, is principal debtor, O is the creditor, Z stands as surety for K. Government by legislation exempts Harijans from the private debts. Thus, Z's liability shall also come to an end by operation of law. And the fourth one, that is compromise as provided under section 135 of the Indian Contract Act, if creditor and debtor compromise, the liability of the surety shall come to an end. And the fifth one, that is regarding release of security as provided under section 141 of the Act. So, if the creditor releases the security kept against debt, then the liability of the surety shall come to an end. Such discharge takes place on account of the conduct of the creditor. So the Contract Act has created rights and liabilities, but the parties have got a right to contract out of the rights and liabilities mentioned in the contract, that is envisaged by section 128 of the Contract Act. Therefore, as it was decided in the leading case, Srimati or Leelavati versus Bank of Baroda and others in 1987 by the Karnataka High Court. That is, therefore, merely because the words notwithstanding anything content to the contrary, etc., do not occur in section 141, it does not follow that the parties cannot contract out of the rights and liabilities as laid down in section 141 as it was held by the Karnataka High Court in the leading case Srimati R. Leelavati versus Bank of Baroda and others in 1987, and the next one, that is the inconsistent act of the creditor as provided under section 139. So a surety is discharged upon the creditor's act or omission inconsistent with the right of the surety or omits to do any duty which he is bound to do to the surety, and if the eventual remedy of the surety against the principal debtor is thereby improved, the surety is discharged. So, in that connection, we'll discuss the important leading case Bhavani Shankar Patra versus State Bank of India and others. In 1986, the Odisha High Court held that surety is discharged when the creditor does or omits to do an act which his duty to surety requires him to do, and eventual remedy of surety is impaired as consequence thereof. And the seventh one, that is death of surety as provided under section 131. So, a surety is discharged either by revocation or by death. It is settled law that a surety is responsible only when default is discharge of obligation on the part of debtor takes place. It is the duty of every party taking a guarantee to put the surety in possession of all the facts likely to affect the degree of his responsibility, and if he neglects to, it is at his peril. A surety ought to be appointed with whole contract entered into his principal. And the eighth one, that is relating to automatic discharge as provided under section 144 of the Contract Act. According to section 144 of the Contract Act, if co-sureties do not join, the sureties automatically discharged. The section runs as follows: where a person gives guarantees upon a contract that a creditor shall not act upon it until another person has joined in it as co-surety, the guarantee is not valid if the other person does not join it, and those surety who enter into the obligation upon the understanding and faith that another person would also enter into it has a right in equity to be released on the ground that the instrument has not been executed by the intended co-surety. And the last one, that is the ninth one, as regarding by invalidity of guarantee as provided under section 142 and section 143 of the Indian Contract Act 1872. So it deals with guarantees which are invalid and thus discharging this surety. And under this head come the following two cases. One is guarantee obtained by misrepresentation. Invalid any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent as concerning a material part of the transaction is invalid as provided under section 142 of the Indian Contract Act. And secondly, guarantee obtained by concealment of certain facts which also makes it invalid. Any guarantee which the creditor has obtained by means of keeping silence to material circumstances is invalid as provided under section 143 of the Indian Contract Act. So the following two conditions must be fulfilled before section 143 can be made applicable. And circumstances, one is there must be a silence on the part of the creditor as to a material circumstance, and the second condition, the guarantee must have been obtained by such silence. So keeping silence means intentional concealment of a material fact as distinguished from a mere non-disclosure thereof. Some elements of fraud must exist in such, and some illustration relating to those circumstances. So the first illustration, A engages B as clerk to collect money for him. B fails so to account for some of his receipts, and A in consequence calls upon him to furnish security for his duty and accounting. She gives his guarantee for B's accounting. It does not acquaint C with B's previous conduct. B afterwards makes default. The guarantee is invalid. And we'll go to another illustration. A guarantees to C payment for iron to be supplied by him to B to the amount of 2,000 tons. B and C have privately agreed that we should pay 5 rupees per ton beyond the market price. Such excess to be applied in liquidation of an old debt, and this agreement is cancelled from A. So A is not liable as surety. So in this question, that is the question number 5, relating, state the circumstances in discharge in which a surety is discharged. So, regarding discharge of a surety, we almost deal all the circumstances also, all the important illustrations and leading cases, and our next upcoming video will concentrate on question number 6, that is discuss the law as to liability of co-sureties with illustration and the provisions of section 146 and 147, and also question number 7, distinguish contract of guarantee from contract of indemnity, and relating to that the decisions or observations made in the leading case Sutton and Company versus Gray in 1894 by the Queen's Bench, and Brigmere versus Darnell in 1744. So, in our upcoming video, we will discuss in detail question number 6 and 7.